This week we're going to look at how has the Constitution been changed to further the ideas of the Declaration of Independence. It's going to be lesson 15, 17, 18, 19, and 20. Essential question, lesson 15, how have amendments and judicial review changed the Constitution? Lesson 17, how did the Civil War test and transform the American constitutional system? Lesson 18, how has the Due Process Clause of the 14th Amendment changed the Constitution? Lesson 19, how has the Equal Protection Clause of the 14th Amendment changed the Constitution? And lesson 20, how has the right to vote been expanded since the adoption of the Constitution? Students will be able to, lesson 15, identify major categories of constitutional amendments. Lesson 17, explain how the Civil War led to the creation of the 13th, 14th, and 15th Amendments. Lesson 18, explain the difference between procedural and substantive due process. Lesson 19, evaluate, take, and defend a position on how conflicts between or among rights should be resolved. And lesson 20, evaluate, take, and defend positions on how existing the right to vote is related to fundamental ideas and principles of American constitutional government. Florida standards. Explain why rights have limits and are not absolute, and we're going to contrast how the Constitution safeguards and limits individual rights. Here's our key vocabulary: adversary system, due process of law, fundamental rights, incorporation, procedural due process, substantive due process, abolitionist, literacy test, poll tax, secession, enfranchisement, franchise, equality of condition, equality of opportunity, intermediate scrutiny, rational basis, separate but equal, strict scrutiny, amendment, and judicial review. Okay, lesson 16, how and why did the framers devise an amendment process? So the framers intended the Constitution to be and to remain a fundamental framework of law. They also knew that one day there might be circumstances or changes that might have to go with the time, so the amendment process is going to be in there. And they also did not want the Constitution to be confused with ordinary laws and regulations. They also didn't want it to be easy just to amend the Constitution anytime with just ordinary type of laws that are made by the Congress and then signed by the President. They did recognize that American society and conditions would change over time, and the framers made the Constitution difficult to amend, but not as difficult to amend the Articles of Confederation. To amend the Articles of Confederation, you had to have all 13 states all unanimously wanting to change the Articles. So with our Constitution, its goal is to protect minority groups. But if you wanted to change the Constitution, it's only been done 27 times in our history of 231 years. You had to have a proposal to create the Constitution. Now, there's two ways to do it. Only one has kind of been the status quo. The other one has never ever been done before. So the first way to propose a constitutional amendment is that you had to get 2/3 of Congress, so 2/3 of the House of Representatives and 2/3 of the Senate. The other way, which has never been done before, is the states would hold conventions and then 2/3 of them would propose. So basically, you don't even have to have Congress. You just have to have the convention of states, and 2/3 of the states would propose a constitutional amendment. The other way, step two, proposal is step one. Step two is going to be the ratification. This is where we add it to the Constitution itself. So Congress is going to be out of this picture. The national government is going to be out of this picture. It's going to be up to the states. Now, there's two ways to do it. You have 3/4 state legislatures or 3/4 of state conventions. Okay, so states will send representatives that are representing them to a city, and then they discuss it, and then it's going to be 3/4 of what they want to do. Okay, so first part is proposal, 2/3. Second part, ratification. You got to get 3/4 of the states. So, what types of constitutional amendments have been adopted? Well, the Bill of Rights are Amendments 1 through 10. We're going to have some fundamental changes, like slavery is the 13th Amendment, and the 14th Amendment is going to change the definition, or excuse me, it's going to define what a citizen is, and states are going to have to recognize due process. Expansion of voting rights, aka suffrage, that's the 15th, 19th, 24th, and 26th. Overturning Supreme Court decisions like the 11th and 16th Amendment. Refinements, which is kind of dealing with the president, is going to be some changes made to the Electoral College in the 12th Amendment. 20th Amendment is going to come out, something called the Lame Duck Amendment. We'll talk about more about that when we get to the presidency. The 22nd Amendment is going to be term limits. 25th Amendment is going to be about presidential disability. We'll get more into detail with these when we get to the presidency portion of our class. And also morality, like the 18th Amendment and 21st Amendment dealt with alcohol. Okay, so why was a Bill of Rights proposed for the United States Constitution? Well, the Bill of Rights is going to be insisted upon by the Anti-Federalists. So during the ratification debates, some opponents, Anti-Federalists, argue that the lack of Bill of Rights opened the door to tyranny in national government. So the Anti-Federalists were really, really scared, and right ought to be, because they lived under a national government that exposed and expanded tyranny. So the Anti-Federalists really have some reservations about this, and because they lived under that system, they have every right to believe that. So George Washington is going to urge Congress to amend the Constitution to express reverence for the characteristic rights of free men and a regard for public harmony. So at the ratification of the United States Constitution, okay, the Anti-Federalists are going to sign along and be with the Constitution as long as the Bill of Rights were in there, making sure that individual liberties existed and state rights existed. What an individual liberty is, what we call civil liberties, is protections from government. Okay, don't get these confused with civil rights. Civil rights is positive acts for government for equality, but civil liberties are protections from government action, like freedom of speech, freedom of religion, due process, unreasonable search and seizures. All of those are all civil liberties. Okay, so the Constitution is going to allow what we call judicial review by the courts. It does have some controversy, but it is a power that the courts have. So judicial review is when the courts have the power to declare what the Constitution means and whether the actions of government officials violate the Constitution. Okay, so this is going to be put into action by a court case called Marbury versus Madison in 1803. So Marbury versus Madison is it's a really interesting story, and we're going to talk about it when we get to the judicial branch. Basically, what happened was it goes back to the election of 1800 between Federalist John Adams and Republican Thomas Jefferson. So John Adams is going to lose the election. He's very, very bitter about it. So what he does is that he's going to nominate and get confirmed by the Senate a whole bunch of district judges, and what his hope is that he's going to appoint these new judges, and they're just going to carry out his legacy. And one of these judges, we call these the midnight judges, if you remember from U.S. history, and one of these judges that are going to be guaranteed a judgeship is a judge named William Marbury. Okay, Thomas Jefferson is going to come into office, and he's going to see a stack of judgeships that he's supposed to deliver, or have his Secretary of State, James Madison, deliver to all these judgeships. But Thomas Jefferson believed that there was way too many Federalists in the federal judiciary. He did not want Federalists. He wanted more Democratic Republicans. And so he said, well, I'm just not going to deliver the commissions, and he basically throws them all in a trash can. Okay, so Marbury believes that he has a right to sue Secretary of State James Madison and the Jefferson administration because they did not faithfully execute the law. Okay, now we'll spend more time on this in class when we get to the judiciary. So there's a lot of drama. There's a lot of back and forth that goes on. But what Chief Justice, the Chief Justice at the time, John Marshall, says is that there's a problem with a certain law that was enacted in 1789. The law that was that was a problem was the Judiciary Act of 1789, and in it was that gave the courts the power of something called a writ of mandamus. And a writ of mandamus is a mandate where the courts can order the executive branch to carry out law. Okay, so Marbury looks like that he's about to win this case, but there's a problem. Because of the Supreme Court says that part of the Judiciary Act of 1789, the writ of mandamus, he finds that it is unconstitutional. The Supreme Court does not have the right to issue a mandate forcing the presidency to do something. Okay, and that's what Marbury is wanting to do. So Marbury looks like he was about to win, but then he loses. Okay, even though Thomas Jefferson did not faithfully execute the law and Marbury has a right to sue, the Supreme Court cannot mandate or do anything about it. And why this is considered unconstitutional and why the point of judicial review is going to come into play here is because that part of the Judiciary Act of 1789, the writ of mandamus, nullifies Article 3, the judicial branch of the United States Constitution. Okay? The problem is that you just can't nullify a part of the Constitution. Okay? No law can do that because of the supremacy clause. The Constitution is the supreme law of the land. So, John Marshall in the court is going to render that part of the Judiciary Act of 1789 unconstitutional. And that's how we get judicial review. The court's most powerful power of the Constitution. So what does judicial review do? So the people exercise their sovereign power when they adopted the Constitution. Congress, the executive branch, and the states reflect temporary, fleeting views on what the law is. The three branches conflict with fundamental law of the Constitution, and judges are in the best position to declare what the law means because they're quote-unquote free from politics. So when it comes to the government, the judges, the Supreme Court of the United States, are the only ones that can determine what the Constitution means. And that's why it could be so controversial, because you are allowing 9 judges that have not been elected, even though they're free from politics, determine what the Constitution means. Okay, so the Constitution is from the convention is going to have some unanswered questions. So how did the Constitution issues lay foundations for the Civil War? So we are going to have the Three-Fifths Compromise. It is going to give slave-holding states additional representation in Congress based on the population of their slaves. There is going to be a slave trade ban that is going to happen in 1808. So after 1808, slaves cannot be imported from Africa. That's going to be part of the compromise as well. But the issue of slavery is going to be kicked down the road for another time, and it's going to come on a pretty bad day, some 90 years later, called the American Civil War, and it's going to be a pretty bad day. So the Constitution did not give Congress power over slavery within its territories. The Northwest Territory Ordinance of 1787 banned slavery in the new states. So now what the Constitution has done is that it's going to leave up the issue of slavery by either some type of legal action that's done by Congress or by what we call popular sovereignty. Okay, so let the states decide. So the Missouri Compromise is going to deal with the issues of slavery a little bit. So the main thing that the Missouri Compromise is going to come out with in 1820 is that if a free state comes into into the Union, a slave state needs to come in as well. Okay, so a free state comes in, you got to have a slave state. Slavery is not going to exist above above, I believe it's the 30th parallel. Basically, it's the line that separates North Carolina and Virginia and Tennessee and Kentucky. Slavery is not going to exist above that line, but below the line is going to be up to the states. Okay. This is going to be nullified from the Compromise of 1850 and also the Kansas and Nebraska Act. So with the Kansas and Nebraska Act, we're having all this new territory came out from the Mexican War. But what the Kansas and Nebraska Act is going to do is that it doesn't matter. It basically nullifies the Missouri Compromise. So it doesn't matter where new territory is gained. If you have a state that wants slavery in the northern parts of the country, like modern day Montana, they have a right to enact that. This is going to cause many civil wars that are going to break out, and eventually it's going to lead to our Civil War. Fugitive Slave Acts are going to be a hard one as well. There's going to be a Fugitive Slave Act of 1793, but it's not going to be enforced. No one's really going to do anything much about it. But the Fugitive Slave Law of 1850 is going to be hardcore, very, 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 very effective at going after people of color in northern states, free states. Whether you're free or you're a runaway slave, it doesn't matter. They're going to put you in chains and send you on downriver to a plantation to be sold. Okay, so 1793, hardly enforced. Fugitive Slave Law of 1850, strictly enforced. Also, Dred Scott versus Sanford. Dred Scott is going to sue for his freedom because his master is going to die, and their station and his master is a army surgeon, and he ends up dying in the territory that we know as Wisconsin today. So he's in free territory. So he's going to be returned to his master's family, but he believes that since he's in free territory, he has a right to sue for his freedom. So the Supreme Court listens to it, and the Supreme Court basically says that since he is a slave, he is property. He does not have any rights. He is not a man. Therefore, he's not a citizen of the United States and does not have a right to sue. Okay, so what constitutional issues did the Civil War provoke? So President Lincoln's goal was to preserve the Union at the start of the Civil War. He believed the public duty of the president was defending the Constitution. So he refused to recognize the right of secession and always called the war of domestic insurrection. So clearly in Abraham Lincoln's mind that states do not have the right to secede. Assertion and unprecedented presidential powers on behalf of the Union by calling up militias to oppose Confederate militias. So Abraham Lincoln is going to believe that he's going to have what he calls war powers, and that he's going to believe that he's going to get this from the Constitution. So Congress does declare war, but when it comes to matters of war, defending the country or any type of war efforts, is going to be up to the president. So the president is going to call up armies, state militias, that's eventually going to become the Army of the Potomac, the Union Army, to put down and go out and oppose these Confederate militias. Now, Abraham Lincoln did some really good things, but he's going to do some very questionable things, like suspension of the writ of habeas corpus in Maryland. So Washington, D.C., if you've ever been there, it's between two states. It's the state of Maryland's to the north, Virginia's to the south. Virginia at the Civil War had already seceded. It's part of the Confederate States of America. Maryland did have slaves. I mean, slavery existed as far north as Delaware, and Maryland did send a few regiments of troops to fight for the Confederacy. But if Maryland fell to the Confederacy, Washington, D.C. would also fall. So to make sure that Washington, D.C. did not fall to the Confederacy, Abraham Lincoln suspended the writ of habeas corpus. So if you said anything that criticized Abraham Lincoln, anything that criticized the United States government, anything that was pro-Confederacy, you would be arrested, thrown in jail without trial, without due process, and you would just basically sit out the entire war in prison. No questions asked, no examination of evidence, nothing. That's what Abraham Lincoln had to do to preserve the Union. And there's also going to be some problems and successes with the Emancipation Proclamation. With the Emancipation Proclamation, Abraham Lincoln, through executive order, is going to free all slaves in seceding states. So what it does is that it pivots the war not only to be a issue on secession, preserving the Union, but also to a humanitarian standpoint by freeing the slaves. That was a success. It was hailed as a huge success for Lincoln in the North. However, the problem with it was that it did not free a single slave, because what he was doing was that he was, at the time, issuing an executive order for a foreign country. The Confederate States of America at the time was a foreign entity. So when the Confederates read the Emancipation Proclamation, nothing really happened. Okay, they just saw it as being nothing. It's like the Prime Minister of Canada issuing out an executive order that would affect the United States. That's the way to look at it. Okay, so how did the Civil War resolve issues that the framers left unanswered? So by the summer of 1865, Congress debated and proposed the 13th Amendment, which would ban slavery except as a punishment for crime. So when the Confederate States came back into the Union, because by this time the war was almost pretty much settled, that if the Confederate States wanted to come back into the Union, well, they would be forced to come back, but they had to adopt the 13th Amendment, which basically would guarantee emancipation for all 6 million slaves in the South. The end of the Civil War is going to bring out the 14th and 15th Amendments with the definition of what a citizen is, and that's going to overturn Dred Scott versus Sanford. And what the 15th Amendment is going to do is that it's going to guarantee voting rights regardless of color, regardless of race. So what that means is that people who were African American men who were once slaves now have the right to vote. Okay, let's talk about what is due process of law. So it's the government's job to protect life, liberty, and property. So the government must follow known established procedures and may not act arbitrarily or unpredictably in negatively altering or destroying life, liberty, or property. So that means that government cannot kill you just whenever it wants. Government cannot repossess your property whenever it wants. There has to be some type of reason. The Fifth Amendment and the 14th Amendment is going to play out on what due process is. Okay, so that means if you're being convicted of a crime, well, we're just not going to go out and just execute you. Okay, you may be charged with capital murder, but there's going to be an investigation. There's going to be a process. Okay, your right of trial by jury, your right to have a lawyer. All these different rights, and then the examination of evidence, and then you're going to have a jury of your peers to decide what should be your punishment. Those are all part of your due process when it comes to criminal activity. This is why decisions such as this should be made by providers, physicians. So there's two different types of due processes. There's procedural and substantive due process. So let's just take a look at what procedural due process is here. So procedural due process is easier to define, and what I mean by that is that it's actually in the Constitution. So due process of law is meant by the government officials must follow recognized procedures. Okay, we already talked about that earlier. And in procedural due process, government is required to act in certain ways before they take away life, liberty, and property. So owning property. So let's say the government wants to repossess your property because they're building a road. Well, the Constitution says that in this case it's called eminent domain, and in eminent domain, government must compensate you on that repossession of property. Okay. Or if you have some type of idea, okay, we call that intellectual property, okay? If government wants to seize that, they have to compensate you some way, shape, or form, okay? That's actually outlined in the Constitution. Okay, substantive due process is a little bit harder to define. So it refers to the process that government must follow when they make and enforce law. So this could change from time to time. It means that the Constitution usually prohibits some kinds of laws altogether. It is based on the idea that some rights are so fundamental that government must have a compelling or important reason to regulate or to interfere with them. So here's some example here like marry and having children. Government can regulate that. Purchase and use birth control. Raise children. Mentally competent adults to refuse medical treatment. Free speech. Like there's a difference between free speech and what we call clear and present danger. Like call to actions, things of that nature. Like you can't say bomb on an airplane or a fire in a movie theater. Interstate travel, legal voters, the right to vote, religious freedom, and also abortion is on there as well. But there's talk that, it's January 2019. There's talk that that abortion might become a procedural due process sometime in the future, which would change the definition of it because Roe v. Wade is going to allow the woman the right to choose, but it was chosen in a substantive due process way. Okay, so we're going to go even further with due process, and we're going to talk about something called the doctrine of incorporation. So this is going to come out from a court case called Gitlow versus New York in 1925. Gitlow is a socialist, and he was giving out socialist pamphlets on a street corner in New York City back in like 1922, 1923, somewhere in there. This was during the first Red Scare, and New York, the state of New York had a anti-anarchy law. So what that means is that if you're advocating for the if you're looking to violently overthrow the government can take action on you. So Gitlow is going to be arrested, and Gitlow is going to say, "Well, I have the right of free speech. I can do whatever I want." So incorporation is using the due process clause of the 14th Amendment to decide whether various guarantees in Bill of Rights guarantees in the Bill of Rights limit the states as well as the national government. And over time, the Supreme Court, over several different cases, they're going to rule that the due process clause prohibits states from infringing on all rights that are guaranteed in the First Amendment. But in this particular case with Gitlow versus New York, the Supreme Court is going to say that Gitlow was in the wrong because of what we call clear and present danger, which is not protected under the First Amendment.
So you've got the baby, you try to kill it, it's born. About keeping their teenage boy or not keeping their
Okay, so what is meant by equal protection of the law? So the 14th Amendment says no state may deny any person within its jurisdiction the equal protection of law. So the Constitution is going to guarantee fair treatment for all persons regardless of sex, race, national origin, religion, or political views. And Americans are going to be entitled to this guarantee, and they're also going to be entitled to equality of opportunity, where everyone has the right to pursue their own happiness. Okay, so it's kind of like everyone has the right to start at the same starting line, and to get to the finish line, that's going to be up to you on how you do it. And some people are going to have different talents and different abilities in different places. But what you do is what you get to determine on how you finish that particular race.
And this is why, Julie, that legislators, most of whom are men, by the way, shouldn't be telling a woman what she should.
Okay, so what was the separate but equal doctrine, and what was it affects? So this is going to come out from a court case in 1896 called Plessy versus Ferguson. So Plessy is under what we call the grandfather clause. And many states after Reconstruction had these grandfather clauses. So that means that if you are 1/16 African American or more, you are black. Okay? So Plessy was 1/16 African American. If you actually look at a picture of him, he actually looks white, but per his grandfather clause, per Louisiana's grandfather clause, he is considered a black man. So the Supreme Court is going to reject a Louisiana law requiring blacks and whites to ride in different rail cars, and they're going to Plessy is going to say, well, hey, I was denied my equal protection clause under the 14th Amendment. The Supreme Court is going to say, well,
understand that there is a
no.
ethical debate.
They are basically going to say that Louisiana has a right to create this law. So this is what we're going to call separate but equal. So that means that per the 14th Amendment, you can have separate facilities for white and black, but it has to be equal. And we all know that it wasn't really equal. And this is going to be the status quo all the way up until 1954.
Doesn't want the government to be involved in your life. And then he says, this is why.
Okay, so why did the Supreme Court abandon separate but equal in Brown versus Board of Education? So the NAACP goal is to end discrimination, but there's going to be a court case in 1954 called Brown versus Board of Education of Topeka, Kansas. And the court is going to find that separate but equal violates the 14th Amendment's Equal Protection Clause. So just give you a little bit of background. Mr. Brown had a daughter who was, I think she was like 7 or 8 years old, and she was zoned to go to the black school. But to go to the black school, it was further away, and she had to walk in a railroad switchyard to get there. So a railroad switchyard is, think about a huge parking lot with a whole bunch of train tracks with a whole bunch of trains there, train cars, and that's where they kind of hook train cars together and whatnot. So you got to think about yourself, is that a place where a child needs to be? Because a lot of places didn't have bus services back then. So is that where a child needs to be? Well, Mr. Brown, being a good father, said no. So he would rather her go to the other school, the white school. It's closer to home, and she does not have to go through that train yard. Well, the Board of Education of Topeka, Kansas said nope, she needs to go to the black school, and that's the end of it. So the Supreme Court, under Chief Justice Earl Warren, is going to say that this does violate the 14th Amendment. She has a right to go to the other school.
Just like that stereotype of the stupid idiot father on sitcoms. You know, Ray Romano.
Okay, so how has the Supreme Court's interpretation of the Equal Protection Clause changed since Brown? So we're going to talk about different types of scrutiny. So strict scrutiny is laws that deny or dilute the right to vote, impede interstate travel, or appeal to restrict access to the courts are also subject to this level of analysis. Intermediate scrutiny, governments that distinguish between groups because of gender or illegitimacy must prove that laws are related to an important government purpose. And then rational basis. This is going to be the lowest level, and we're going to go through these levels in class. Courts presume that the deliberate process that legislatures use to enact laws ensures rationality. So we're going to take a look at these different ones because the lower level is where the courts are going to presume that there's some type of deliberate process, all the way up to strict scrutiny, which is basically when it comes to subjects to like denying people the right to vote.
Holster so that it will fit comfortably and securely at all times. You can place the holster on your waistband, change the angle. It's just
Okay, so why is the franchise? So why is franchisement important in the American constitutional system? So franchise refers to the right or privilege. In our case, it's the right to vote. Enfranchisement is the act of giving that right to vote to a person or a group of people. So it's basically asking the question, who has stakes in government? Back in the old days, back in like the 1700s, early 1800s, the founders believed that if you paid taxes, you had some type of stake in government. Well, over time, it has evolved to, well, if you're a citizen, if you were born to this country, then you automatically should be given the right to vote because you automatically have a stake in the government. So if you can be called into service through a draft, then you should be given the right to vote.
time they want the government to be involved. The good side of this, it's so, watching that, you get so
So how was the suffrage? So how was the suffrage determined when the Constitution was adopted? So the Constitution is not going to address suffrage at all on a national scale. They're going to leave that to the states. Even today, when it comes to voting dates and how voting precincts are done, that is up to the states. The national government does not get involved with that. That's why states will have something called secretaries of states. They deal with elections. The states get to determine who votes and who doesn't get to vote. That's totally up to them. So many states did not allow people who did not own property to vote. Like in Virginia, I think you were required to at least own 25 acres. Therefore, you're paying property tax. Therefore, you are vested in government, so therefore it gives you the right to vote. But some states like New Jersey, women were allowed to vote because they were considered all inhabitants. So that means is that if you lived in the state of New Jersey, you met property and residency requirements, you had the right to vote.
Instances, you have the left and the right following their ideas to their logical conclusions. So, if abortion is wrong,
All right, so how was suffrage extended to women? So women getting the right to vote, that was up to the states. You had some states like in New Jersey as early as 1776, but they're going to get rid of that in 1807 for political reasons. Montana, when they become part of the Union, they are going to let women vote. But nationally, there's no part. So the Constitution is going to be, well, there's no enforcement mechanism. So this is where the 19th Amendment is going to come into play. So the 19th Amendment is going to forbid states and the United States from denying or abridging the rights of citizens to vote on the basis of sex. So this is going to give women suffrage.
not wrong when they enter kindergarten. They're taking their idea to its conclusion. The left has been
And our last one here is how did 18-year-olds win the right to vote? So before the passage of the 26th Amendment in 1971, there was no set age. The status quo was 21. So the amendment is going to prohibit both the United States and the states from denying or abridging the right to vote for citizens age 18 or older. So the argument was that if you're sending 18-year-olds, if you're drafting them to go fight in Vietnam, they should have the right to vote. So this is where this is where many in the country are going to say, well, yeah, if you're 18, if you're old enough to go fight for your country, then you should be given suffrage rights.